Welcome to Workplace Wake Up, your go-to podcast for practical employment law guidance. I'm Jennifer Shaw, the founder of Shaw Law Group, and I'm here to help HR professionals and leaders navigate the legal minefields of the modern workplace. Each week, we tackle real-world issues with clear advice and a little tough love. Let's get started. Thank you for joining me today. I cannot believe we're in the month of February. This is crazy. Okay, so we have been talking an awful lot about ICE and Minneapolis and all kinds of things. And honestly, I went back and forth about whether I should talk about this. And I finally decided I think we need to, even though it's calming down in some ways. I think it provides a lot of good lessons for us. So obviously, the news that's happening in the world can certainly show up in the workplace. And this happens all the time, right? Whether we're talking about the economy, or we're talking about an election, or we're talking about what's going on in Congress, or we're talking about ICE and Minneapolis and lots of other places and what's going on in terms of immigration. So one of the things that I think employers really need to think about is, how are we going to deal with these conversations? Because certainly, especially in a state like California, but really anywhere, you can't just ignore the subject or shut down the conversations. Because when you do that, you really are denying your employees the ability to process information in the place where they spend a lot of time every day. Certainly when you're dealing with full-time employees, they may spend more time with people at work than they do with people at home. So if we tell them, look, you can't talk about what's going on with ICE, or you can't talk about what's going on with President Trump, or you can't talk about what's going on with the climate, whatever it is. When you shut down the conversation, you are really going to create morale issues in the organization. So I want to talk to you today a little bit more about this issue of what do we do as a California employer. And we've talked about this issue in the past. For example, I think the last time we brought it up was during the last presidential election back in November of 2024, and really thinking about what kind of limitations California employers can put on their employees when it comes to talking about these kinds of issues at work. So here's the reality check that I think we all need to understand. Whether you have a policy that prohibits discussion of current events or not, employees are talking. They're talking in meetings. They're talking on Slack. They're talking in break rooms. They're texting during meetings. And remember that just because you may not be hearing the conversations doesn't mean that they're not happening. And if you don't take some sort of a position, and I don't mean a political position, a position on the conversations and whether they can happen and under what circumstances. If you don't take some sort of position on that, you're really not being neutral, okay? Because silence is really not neutral. And if we don't have a strategy and we don't plan this out, and then somebody gets upset in leadership because another employee says something they don't like or they disagree with, and they respond from sort of a panic perspective, those are never very effective responses. We are always going to want to plan these things out a little better than that. So let's talk about what California law really cares about, okay? Because this is important. The law does not care about opinions. Everybody in California has a right to talk about their opinions, to think about their opinions. Remember, under the federal Constitution, okay, the U.S. Constitution, freedom of speech is only available against state actors, right? The Bill of Rights was to protect against overreach by the government. If you are a private sector employer outside of California, you may not have to worry about your employees' First Amendment or free speech rights. But in California, we have our own constitution, and our constitution allows employees the freedom of expression and freedom of speech, whether they work for a government employer or not. So when you think about California focus from a legal perspective, it is not opinions. Everybody has the right to express their opinions at work. It's really about the conduct. And when we talk about the Fair Employment and Housing Act, we're really looking at when does that law get triggered, right? When we talk about, remember, the FEHA, the Fair Employment and Housing Act, is focused on preventing discrimination, harassment, and retaliation, right? And there are all sorts of other provisions. In California, we have sort of this all-in-one approach to equal employment opportunity, which is different than when we look at, for example, federal law, where we have Title VII of the Civil Rights Act and the Age Discrimination in Employment Act and the Americans with Disabilities Act, all these different laws that provide these protections. But in California, they are mostly under one umbrella called the Fair Employment and Housing Act. Now, when it comes to speaking out and engaging in political activity, we also get a number of protections from the California Labor Code. And the reason for that is simple. When you are an employer and you decide that you're going to punish someone for a protest they went to, or you're going to demote someone because they spoke out on an issue that you disagree with on social media, you're not only potentially raising a discrimination issue under the Fair Employment and Housing Act, but you have labor code provisions because you're affecting the terms and conditions of their employment. So when we talk about the legal framework for free speech protections or political activity, we are really looking at the Fair Employment and Housing Act here in California and also the California Labor Code, which, by the way, is a huge, thick morass of laws, right? There's a lot in the California Labor Code. Now, if you think about the basic requirements, right, of the FEHA and the Labor Code, the general premise is, look, we hire people to do their job. And if they want to explain their views about a particular issue or they want to engage in some sort of political activity, that's fine as long as it doesn't interfere with their ability to get their job done, right? That's really what we're focused on is, are they still doing the work that they're supposed to be doing? So how do we muck this up as employers, right? How do we screw this up? Well, the first thing we do is we have a knee-jerk reaction, right? We don't plan this out. We don't think about it in advance. And all of a sudden, somebody gets very upset. So I'll give you an example. Today, I get a call from a client. The owner of the company is very upset because they have a new employee who is transitioning from male to female. And that employee was instructed to come to a meeting today, prepared to move a lot of equipment. And the person showed up in a leather miniskirt and stiletto heels. Now, what's interesting about that is the owner of the company was very focused on the transition issue. This particular organization has a pretty high profile, and the leader was concerned, understandably, about how this employee might be received by a particular population. He was ready to fire the employee based on that. And of course, instead, if you take a deep breath and you think it through, you say, well, wait a minute, transgender has nothing to do with anything here. The real problem is this employee showed up for an assignment after being told he would be moving a lot of equipment and really having to dig in there and get dirty, literally told wear jeans, wear sneakers, wear something that you can mess up, right? And instead shows up really inappropriately dressed for the moment. It took us a few minutes, but the HR person and I finally convinced the owner, look, the transgender issue has nothing to do with anything. If this were a biological female employee or an employee who identified as female, and they came dressed this way, you wouldn't tolerate it. You gave them a very specific instruction about what they were supposed to be wearing, and they didn't do it. Don't create an issue where there's not an issue, right? This knee-jerk response is tough, and it can create a lot of liability for you. Now, here's the thing. I am famous for doing this because I get emotional about what's going on in the world and what's happening and what people are saying and what people are doing. And I find myself reacting in an emotional way when I talk to people about it at work. And I really have to think much more than I do about how what I say can land with other people, especially because in my particular situation, I sign their paychecks. So there's certainly a perceived power, and I guess an actual power, although I don't like to think of it that way, dynamic that is present. So when I start explaining my views about something, they could carry more weight than somebody else's views, just by virtue of my position in the organization. I have a responsibility to think that through carefully and figure out how my comments or how my conduct may land on someone else, right? Another mistake we make as employers is we discipline the tone of the discussion. You were loud, you were rude, you interrupted someone, rather than the behavior, right? So certainly the interrupting someone is behavior that we could tell the employee, listen, that's not acceptable, right? That's disrespectful. But somebody's tone or the actual position that they're taking on an issue should not be the reason that we're holding the employees accountable, right? It should be much more about what is their conduct, what is their behavior. Another mistake we make as employers is we don't help our leaders figure out how they should handle these situations. We just tell them, oh, you're smart, you'll figure it out, don't worry about it, you've got this. But that doesn't work. There was this amazing young woman, her name is Taryn Smith. A couple of weeks ago, she finished a row across the Atlantic Ocean, all right? She ended up, I think she started in the Canary Islands and she ended up in the Caribbean. She went like 3,028 miles or something. And it was so interesting to me because what she talked about during this row, she would give this little video update every night, which I watched because I was just mesmerized. Like, I would be so scared being in the middle of the Atlantic Ocean by myself with these huge 40-foot waves crashing over the top of her. It's not really a rowboat. It was kind of a big sort of canoe-y type thing, but still, I mean, it's not a big boat. I would have been so afraid. And what she kept saying is, listen, I planned for this. I actually lived on this boat for 7 weeks in the UK last year, in the middle of the ocean, like in the Atlantic Sea, which was really choppy and a lot of stuff going on. I've already done this, right? So I'm prepared. And when she came in today, she beat a lot of the estimates for how long they thought it would take. She's the first U.S. woman to ever do a solo row across the Atlantic Ocean. I was pretty amazing. She's 25 years old. But what really stuck with me was she prepared. This is the thing we don't do sometimes. We don't give our managers preparation. We don't help them with talking points. We let them freelance their responses. And a lot of times, our gut is not going to be the best judge of what we should be doing. We need to think things through. We need to have a plan. We need to have a strategy. So what do I want you to do instead when we're dealing with these political issues and emotional topics at work? Set clear expectations, right? Let everybody know, listen, you are welcome to espouse your views here in this workplace, but you have to do so respectfully and professionally. And you can't attack other people for what their views may be. We're going to give leaders scripts, right? Help them understand when somebody goes a little off of the plan, right? They go a little too far in expressing what they're doing. The manager, the leader, the supervisor has to know what exactly can they say to get that employee back on track. And we want to be focusing on professionalism and safety at work rather than viewpoints, rather than this idea of, do you agree with me? Or is your viewpoint well documented or well supported by the facts or by the law or by some philosophical viewpoint that may be out there? So here's the reality, everyone. You cannot control what employees think or feel or post on social media. You just can't. But in California, you can and you must manage how those conversations show up at work. Remember, the goal is not silence. We are not trying to stop the conversations. What we are trying to do is keep the discussions from turning into harassment, safety issues, or legal exposure. Now, if this feels familiar, you're not alone. And this is exactly why these kinds of situations deserve a plan and not a reaction. So I want you to think about this over the next week until the next podcast. Really give this some attention. How are you dealing with these conversations in your workplace? Do you have policies and procedures to guide employees? What are you doing to support your leaders so they understand how to tackle an issue when something gets out of control? The more planning you do in this area, the better your response will be. You will be able to preserve the morale of the organization and stay out of legal trouble. All right, everybody, thank you so much for joining me here today. I will see you next week. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. Thank you for joining me on this episode of Workplace Wake Up. If you found today's discussion helpful, be sure to subscribe, leave a review, and share the podcast with your HR and leadership teams. For more insights, training programs, and legal updates, you can visit us at shawlawgroup.com.